Welcome back. The Administration of Criminal Justice Act 2015 is effectively the fulcrum around which the current clamour for judicial reform in Nigeria revolves. A defective implementation or application of the provisions of the Act has been blamed for the country's overflow in prisons, inability of the courts to ensure speedy dispensation of justice, protection of the rights and interest of the suspects, and of course the defendants and victims. As the Tinubu administration gathers momentum, it is expected to pay more than a passing attention to the issue of judicial reform. Michael Aondoakaa, senior advocate of Nigeria, is a former Attorney General and Minister of Justice. He joins us now to offer his thoughts on how the government can proceed in this direction. Many thanks for joining us, sir. Writing on the Criminal Justice Act 2015, what sort of judicial reforms are you expecting or will suggest for the Tinubu presidency, and of course why?
Thank you very much. The country or the National Assembly also started one aspect of judicial reforms that everybody has been yearning for, and I think it is in the right direction. The National Assembly initiated a constitutional amendment that focused on the tenure of judicial officers, harmonization of their ages of retirement. To me, it's a move in the right direction, because if you see, a lot of judges retire at 65, and it's very enormous on the part of the administration of criminal justice when at 65, somebody is healthy, he retires, and you start the process of getting new judges, you start the process of getting accommodation for them, you started the process of getting new vehicles for them. I think it is the wisdom that amendment by the National Assembly, which actually it was a constitutional amendment, it was already passed by two-thirds of the houses of assembly of the states of the federation, more than two-thirds. Since March 8th, it was transmitted to the president to sign. Unfortunately, that has not yet been done. We expect the current president to sign before this 9th National Assembly elapsed on the 12th. Another aspect was the request by the Court of Appeal for amendment of their act to increase the number of judges from the current 90 to 110. It was also done by the National Assembly as part of the Judicial to increase the manpower of the Court of Appeal. It was sent to Mr. President on the 8th of March 2023. Unfortunately, the former president, whether he signed or not, I don't know, but it has remained there. And it is unfortunate it has remained there, because currently additional judges were sworn in by the Chief Justice of Nigeria, 39 of them precisely, to go for the election tribunals. You can imagine the number of appeals that will go to the Court of Appeal and the regular cases pending at the Court of Appeal. And a simple request like that, I did not see any problem with that, and I did not see who, at the end of the day, told the former president not to sign. It was to me, it was a little not proper. Let's take the case of the constitutional amendment that harmonized the retirement age and say judicial officers should retire, all judicial officers should voluntarily retire at 65 and compulsorily at 70. My position has been, and when I was Attorney General, is that if there's a constitutional review and any party, including the federal government, has issues, it is at the time deliberations are being done by National Assembly. The National Assembly conducted a public hearing, and one expected nobody is above the law. Anybody involved, including the executive, then, if they had any objection, they would have gone there to present areas of objection. When the amendment was done, the fifth alteration was done to do the harmonization, sent to the states. The state also, their houses of assembly deliberate, and then more than 2/3 of the state houses are so concord. And then the constitutional amendment is effected and transmitted to the federal government, to the president to sign. If anybody goes now to advise otherwise, it's an abuse of power. To me, it's clearly an abuse of power. Because you can imagine the industry involved in the 2 chambers of the National Assembly, the public hearing they took. You can imagine the industries, the houses of assembly of all the states, the 24 states took, or more than 24 took, to review and pass the amendment. And for a single person to advise the president otherwise, not to sign since March, to me, is an impediment on the administration of justice, which we are yearning for. And I expect that the current president should go in and sign those 2 legislation as a matter of urgency. The Court of Appeal needs judges, additional judges. Nobody in the legal system will say that the judges we have now are adequate. An appellate court is not expected to have more than 5 cases on the court list. But if you go to the Court of Appeal, even today, you go to the Court of Appeal, you see the Court of Appeal is having 17 to 21 cases on the court list. Humanly, it's not possible. If anybody now comes to object to an amendment which was duly done by the National Assembly and sent to the President to assent, and it's being ignored, it's not in good faith. And I expect the current President, Bola Ahmed, to step in and sign those legislation, along with the legislation relating to the communization of judicial officers. Because I am on a strong opinion. During my time, if a constitutional alteration is done, I do participate at the time the alteration is being done. But at the conclusion and at the time, you can also object as an Attorney General of the Federation at the time the National Assembly is about to transmit to the states, to avoid waste of resources. That is done. And then you allow the State House of Assemblies to deliberate. You never raise any objection. You now allow them to pass and concur with the amendment. You never raise an objection. Then it's forwarded to the president. Then somebody will come, president don't sign. Certainly, that is not good. And I expect that it is for the president, the current president, to step in and demonstrate wisdom that he is ruling according to law and is ready to support the judiciary to do what is right. The judiciary need manpower. Nobody who is a lawyer will know that the judiciary has been grossly understaffed. Apart from serving this, the welfare also is very important for it to be improved. University professors are retiring at the age of 70. There's nothing injurious on this, and I did not see the basis. So these are the areas that we, on our side, ourselves as lawyers, create impediment. The National Assembly is trying their best to make sure that administrative of justice is done efficiently by ensuring that legislation that we create the efficiency of the judiciary is being passed seamlessly by the 2 arms of government. And then, strangely, nothing is done. So I feel that is an area of my concern, and I felt through this medium, the president will do the right thing and sign the harmonization of age, that constitutional amendment, or also give the Court of Appeal the judges they need to do the work.
Very good.
They're not asking for a pay rise. They're simply asking, I want more judges.
All right, Mr. Aondoakaa, interesting perspective there on the Court of Appeal. But let's go a little bit higher. There's also arguments on the need to fill the Supreme Court with constitutionally required 21 justices. Now, what is the current scenario currently regarding the present justices, and why the need for 21 justices?
You see, the volume of litigation, the population of the country is quite advancing. And a country can only guarantee inflow of investment where it has a robust judiciary, where justice is dispensed expeditiously. That is the main thing that guarantees a country an opportunity for direct foreign investment. Nobody will come to invest in a country where there's dispute. It will take 10 years to reach the Supreme Court. Currently, you could know the number of Supreme Court judges has gone as low as 14. That means basically, or as low below 14. At full Supreme Court panel is 7 judges. Therefore, even if they are to do 2 judges or 5 panels, 5 judges or 2 panels, it's 10. They can't form a quorum for the 3rd panel. Volumes of cases are going to Supreme Court, and the Supreme Court list is as if it's a court of first instance. If you look at the court list, you see the Supreme Court having cases out to 15 or more on the court list for hearing, not to talk of applications like motions that will be pending at the Supreme Court. This is humanly not possible. It is expected that anybody involved in the administrative justice, as a matter of urgency, ensure that the Supreme Court is fully staffed to the 21 judges needed so that they can have several panels to deal with the cases. I have always, and every government will always expect Nigerians to settle their differences, or people living in Nigeria to settle their differences using the judicial system. That's what every government is talking about. And therefore, if the system is not efficient, is grossly understaffed, then there's going to be danger. When people lose faith in the judiciary is doing their best. But as human beings, you could not expect a judicial staff, a judicial officer, as a justice of the Supreme Court, to hear 21 cases on the court list in a day. And he's expected by the Constitution to deliver judgment within 90 days. It's a constitutional provision. The time of writing the judgment, the time of hearing the appeals coming from the Court of Appeal. This is very enormous. And we felt, and very reasonable to feel, that it is now time for this present administration to quickly fill the vacancies. If they don't, by November, 3 more judges will be retiring. And what happens? It means we will have something around 11 justices of the Supreme Court, or 10. And in a big country like Nigeria, over 200 million people. So it's not a matter of doing favor. It's a matter of doing what is right for the country. People should be encouraged to settle their differences, their dispute in court. An administrative justice should take lesser period for it from High Court to Supreme Court to terminate. But if there's no judges, there's nothing. Apart from the issue of judges, is the issue of the facilities to do the job, especially voice recording facilities. We are still taking notes even in the Supreme Court manually. And tell me 24 cases coming in, several submissions, you have to look at it, you have to take the notes during the submission manually. You have to go home and write the judgment. These facilities are not satisfactory facilities for justices of the Superior Court to have. So staffing and improving their conditions of service, including their working environment, including their welfare, review of their even remuneration is desirable for them to cope with the workload. For instance, universities are being paid, professors are being paid overtime, overload amounts for students they claim to have supervised more than the statutory number of students in the class. I don't think our judges anybody has thought of paying the judges, because a judge is not supposed to have more than 5 cases on the cost list. They are not being paid for the excess. So it is time for us, this administration, to look into that, ensure the adequate number of judges are filled in the Supreme Court, the number of judges requested by the Court of Appeal is granted, and harmonization of the age retirement age to 70 because there's need, experience matters. There's need to allow judicial officers, even at the High Court, to remain and gather the experience to save cost. Because before you appoint a judge, you have to make provisions for the working, the car, vehicles, and whatever. Then he retires at 35. You're not at 65. You start getting another set of judges. Then you start planning to buy new cars. But this one can at least remain there until 70 years when the activities, when they compulsory retire. Mind you, life expectancy have increased globally by 28%. People are no longer dying as they used to. In Europe, life expectancy has gone to 84%. Even in Nigeria, it has improved to 68%, 68.4%. That is the average that people die now. That is how you should look at our life expectancy. And this is not only the judiciary. I have been so worried when I see the number of major generals retiring. I see a young man, and he'll say, I'm a major general retired. I just laugh at I said, there's something we need to do. We need to look at our laws, including the armed forces laws, and contain a situation where people who are well experienced are retired prematurely at 55, for instance, for the Army, Navy, and Air Force. It looks very funny. And therefore, or police 60 years, when their experience is small. So this is the situation, and I felt it will go into support the administration of justice as it relates to the judicial system. And I feel the the current president has fought a lot of legal battles for Lagos State, which he won through the court. If there was no judiciary, there would not have been anarchy. And he knows exactly where it suits. A country run by rule of law must become a prosperous country.
Indeed.
And rule of law entails rule of law entails quick dispensation of justice.
Okay. Very good.
Justice delayed is justice denied.
Indeed, Mr. Aondoakaa, agreed. Now, I'm going to take you up on you mentioned the settling of dispute and differences. And if we may digress a little regarding the presidential election tribunals, there's agitation that cases should be concluded before a new president is sworn in. How feasible is that given the complexes of individual cases? And of course, can justice be seen to have been served in such circumstances at the end of such elections?
Well, you see, the problem has not been whether cases are concluded before the president has sworn in, but the problem touches on the independence of the judiciary. The judiciary, even when president have cases, the judiciary is not just rule that it's the president. Let's take the issue of Naira redenomination. The president was taken to court. The judges ruled against him. He was still the president and commander-in-chief of the armed forces. They did not say because the president was the one that ordered. Some of them, even in the judgment, gave very strong words. For instance, one of the judges, noble justice, said the action of the president was undemocratic. So that clearly shows the kind of judiciary we have, the independence of the judiciary we have. It does not matter. We cannot single out President Ahmed Bola Tinubu and say that your election, it must be. Election petition must be concluded before he ought to have been sworn in. From Obasanjo time up to Yar'Adua, elections were contested up to 2 years. More than 2 years. In Yar'Adua's period, when I became the Attorney General, there was a split decision of 4-5 in one of the cases. And in one of the other case was 6-1. So you could see the judges are not just there to rubber stamp. And I don't ascribe at all. I have been on this channel before on the issue of saying that you must conclude the election. I gave the reasons which I have not canvassing for. Where is the manpower? How could they finish with all the litigations that has come out of it? How can they finish within that days using their pen to write in the long hand. These are the things I say, look, it is desirable, but it's not realistic. But the Constitution has created a framework. Within 180 days, you must deliver the judgment. And we are hopeful that they will, because this is a constitutional provision. And so we should. Social media can create a help. We have to be very careful. Social media, judges should not be judged based on what comes out of social media, but based on physical realities. If you see social media, they can create a hype. But the volumes of legal arguments are there. They don't have an opportunity. So they can say, finish the case before 7 days. But they don't know the deep involved in argument presented with the issues of law, with the issues of evidence presented by the judges. A hasty conclusion of a trial also amounts to unfair and unjust trial. If the judges are in a hurry and they will overlook the arguments being presented by counsel, and they also reject or they're impatient to take the evidence required, that will also amount to injustice. So the bottom line is that the judges are following the Constitution, and we should allow them to do their work based on what? After all, the argument now is an academic argument. Bola Ahmed Tinubu has been sworn in as President Bola Ahmed Tinubu and Commander-in-Chief of the Armed Forces. So that argument is even not feasible now. It's an academic argument.
All right, Mr. Aondoakaa, I would like you to delve on this. Earlier on, you mentioned it briefly, hopefully in the next 2 minutes. The issue of prison congestion and delayed justice for those awaiting trials. What should the judiciary do to ameliorate this, especially with the the issues you talked about on the Criminal Justice Act 2015 and, of course, reforms, as it were?
The same thing I have canvassed earlier. The judiciary has been doing a lot. For instance, election petitions take priority over all other cases. And because all the judges, most of the judges, substantially now, are involved in election petitions at the tribunal. Almost all are involved at the appellate court, a court of appeal, as appeal courts. Very soon they will be involved. Few of them are involved in the presidential appeal. Regular cases are going to suffer as a result of this. And that's why we felt that if you have an atmosphere where judges are adequately appointed for this, they could know the number of judges that will be dedicated to do criminal justice, to criminal cases for speedy trial. But as of now, the judges are inadequate, both at the High Court, Court of Appeal, and Supreme Court. And there's no time again to say, you do these cases, criminal cases, and don't do this. All of them, there's crisis. And therefore, I feel that we, the judiciary, is ready. Give them all that is necessary for them, and they will do the work.
Indeed, indeed, and that's
they
as
will
much.
Decongest the prison.
Very good, indeed. That's as much time we can take. Mr. Michael Aondoakaa, Assent, former Attorney General of the Federation, Minister of Justice, would like to thank you for your perspective on the reform prospect in the Tinubu presidency. It's good to have you.